Good afternoon, Your Honor. On March 5, 2016, AU Hospital disclosed the medical information of my client, Ms. Jennifer Eden. Contained in these records were her name, address, phone number, complete medical history, labs, imaging, and social history. My client did not authorize the release of her personal health information, nor was she notified that the agency had received a subpoena for her records. Her information was released to the requesting agency without a qualifying court order. AU Hospital did not do their due diligence to ensure that they had a qualified court order before releasing the records on the subpoena. According to the Federal Privacy Act of 1974, no agency shall disclose any record which is contained in a system of records by any means of communication to any person or other agency except pursuant to a written request by or with the prior consent of the individual to whom the patient record pertains. Ms. Eden, can you please state for the record your account of what happened in regards to the release of your medical records by AU Hospital?
I feel very wrong because all of my personal information was given out, which I may now never know whose hands it could possibly end up in. My personal security was breached, and I no longer feel safe in my physical, emotional, and personal security. I, as a patient of AU Hospital, should feel that my personal information will be protected by any means necessary. This could include waiting until I respond about the release of my own personal information. The treatment of the patient, both medically and legally, should always come first, and I, as a patient, should be able to trust that the hospital will ensure this. Patient privacy and confidentiality is an obligation of the hospital, and all employed by the hospital should be trained extensively in this subject. However, this was not the case, and my information was given out without my permission. So much of my information was found in these documents that were subpoenaed, and it is very obvious that it was not ethical to share this information. Much of this information could include my name and the names of my family members, my address, all of my date history, including my birthday and all my hospital admission dates, my phone numbers, my email address, my social security number, my medical records, account numbers, any certificates or licenses I have, vehicle identifiers, device identifiers, my fingerprints, and my personal photographic image. Someone could have all my personal identifiers now and are able to easily steal my identity. This causes a great and lasting concern for me, as I will continually have to worry that someone is out there posing as me, which could ruin my credit and my peace of mind. My personal security is at high risk now, also because people may know where I live and what I look like. I could be a great target now for crimes such as robbery, rape, or murder. I no longer feel safe at my own address, and all of this could have been avoided if the administrative staff at the hospital had looked at the documentation being given out and realized this was a lot of personal detail that needed to be kept safe or within the hands of the patient in order to make a decision about what is done with it. I, Jennifer, was not given a choice in this matter and was ethically and legally wrong by the hospital, and now I have to suffer the effects.
Ladies and gentlemen of the jury, according to Rule 45, Section 164.512 of the Health Information Patient Portability Act of 1996, a HIPAA-covered provider or plan may disclose information to a party issuing a subpoena only if notification requirements of the privacy rule are met. Before responding to a subpoena, the provider or plan should receive evidence that there were reasonable efforts to notify the person who is the subject of the information about the request, so the person has a chance to object to the disclosure or seek a qualified protective order for the information from the court. AU Hospital did not verify the subpoena was court ordered, nor did they notify my client denying her right to seek a qualified protection order to seal her records. Therefore, AU Hospital violated HIPAA regulations by disclosing my client's medical records without her authorization. Ms. Eden had a reasonable expectation that the hospital would properly and reasonably protect her right to privacy. In the case of Emily Burney and Avery Center of Obstetrics and Gynecology, the medical provider released records to an attorney in a paternity suit without giving prior notice to the patient. This information was then used to cause emotional distress, harassment, and extortion by the attorney and his representative. Connecticut Supreme Court ruled that HIPAA privacy rule regulations do not preempt cause of action, and in cases arising from the healthcare provider's breach of confidentiality. Ms. Bryan was awarded for damages in this case. We are seeking damages in the amount of $100,000 in favor of Ms. Jennifer Eden for neglect and breach of contract.